It is February 26th of 2026. And most importantly, it's Jerlay's birthday. Happy birthday, Jerlay. And this is the Court Gallery. Ladies and gentlemen, thank you for joining me this evening. We have a calamity, a cacophony, a crazy set of court cases to watch tonight. We're starting off in Wyandotte, Michigan with Judge DiSanto, and man is she displeased. We're moving quickly over to Ann Arbor, Michigan with Judge Simpson, who's got some crazy cases to hear of his own. We're going to finish things off with Judge Middleton, who has probably the highest OWI-BAC case I have ever heard in my life. And he's going to marry somebody before it's all said and done with. It all starts right now.
So let's go on the record. In the matter of the state of Michigan versus Tiffany Reed, 26240, and in the matter of the state of Michigan versus Steve Gagitis, 26240. Detective, your name for the record, please.
Detective Chelsea Askin.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. And you may proceed on the warrant.
On 2/25/2026 at 1:43 hours, Officer Kay Cox and Stathicus were on patrol in the area of 4th Street and Ford Ave in the city of Wyandotte, Michigan, when they observed a gray Chevy Malibu with window tint to the front, drivers and passenger windows. A lien check indicated the registered owner had a suspended license. A traffic stop was initiated. The driver was identified as Megan Porter, the front passenger was identified as Steve Gagitis, and the rear passenger was identified as Tiffany Reed. Gagitis advised officers they were driving to the hotel. Gagitis was observed to not be wearing a seatbelt. Reed verbally provided her name to officers and stated she had several active traffic warrants. A lien check indicated all three occupants of the vehicle had arrest warrants with local agencies. Reed and Gagitis were suspect in prior controlled substance violations. All occupants were asked to step out of the vehicle. While Gagitis was exiting the vehicle, he made a fast furtive gesture towards his front pocket and waistband area. Gagitis was placed under arrest for a warrant and search. Officer Stathicus located a plastic Ziploc loose in Gagitis' right pant leg. Inside the bag was a crystallized rock substance, which later the field tested positive for amphetamine. Reed was asked to step out of the vehicle and she consented to a search of her person. Officer Cox located a burnt glass pipe with a ball-shaped end in Reed's right jacket pocket. Reed was placed under arrest for narcotics paraphernalia. Officer Cox located 2 more pipes on Reed after a search of her person. Porter was also placed under arrest for loitering with drugs or theft. During a tip of the vehicle, Officer Keegley located a small black purse on the rear seat of the vehicle, which contained documents in Reed's name. Inside, Officer Keegley located a Ziploc bag containing a crystallized rock substance and another Ziploc bag containing the same crystallized rock substance. Both later tested positive for methamphetamine. Officer Keegley located a black drawstring bag on the rear passenger seat with Reed's other belongings. Inside of the backpack was a silver Smith & Wesson handgun with serial number A8351193. The handgun came back unregistered. Reed did not have a valid CPL. The handgun had 1 9mm round chambered and 12 9mm rounds in the magazine. The handgun was made safe and secured as evidence. The methamphetamine seized from Gagitis weighed approximately 7.76 grams. The methamphetamine seized from Reed weighed approximately 2.44 grams and 2.02 grams. Gagitis has an extensive criminal history, including 2 felony convictions. 2000, he was convicted of escape while awaiting trial in the 6th Circuit Court. And in 2005, he was convicted of homicide, manslaughter in the 3rd Circuit Court.
Upon examination of the complaining witness, I find the offenses charged were committed and that there is probable cause to believe the defendants committed those offenses. All right, and counsel, your appearance, please. I believe first we have Miss Reed.
Your Honor, for the record, John Goldclaw, P 30758 on behalf of Ms. Reed. Ms. Reed, please put your name on the record.
Tiffany Reed.
I didn't hear the first part, ma'am.
Tiffany Reed.
Okay. Is there a reason why you're leaning up against the wall?
I don't feel good at all. I've been asked to go to the hospital. They won't take me. I'm in
Okay.
a lot of pain.
Okay. And counsel, as to the arraignment for Miss Reed.
Your Honor, as to the arraignment for Ms. Reed, she would stand new to the charge, waive a poor reading of those charges, ask the plea.
The court will waive the formal reading. You have the right to have an attorney represent you. If you're unable to afford an attorney, you may ask to have one appointed to represent you. And you did have an opportunity to speak to an attorney today. Is that correct, ma'am?
Yes.
The court has also signed the petition order for appointed attorney for felony matters as well. And you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on March 5th.
Eight 45.
At 8:45 a.m. As to bond counsel.
Your Honor, Ms. Reed is, I'm sorry, how old are you, Ms. Reed?
Or,
I did 34. Is that what you said?
yes.
34.
She has no prior felony convictions. She is, for lack of a better term, homeless at this point in time. Indicated she does have no prior felony convictions. She is charged with possession of controlled substance as well as the felony firearm and a CCW. She is single and is living basically with other individuals at this point.
Okay. I tell you I'm in pain. You guys don't understand.
Ma'am?
Ask the judge.
Ma'am, I need you to please pay attention so we can ascertain the appropriate bond.
She has indicated when we spoke that she has not felt well. She has been requesting that the officers take her to the hospital. However, that's why we might get this matter resolved and get her bonded out if possible, or at least have her transferred to the hospital as the term and condition of the bond. As I indicated, she has no prior criminal record. There is
Just because she failed to appear on a matter,
not a criminal matter.
well, there wouldn't,
I've had a felony before my life.
I didn't say felony. Yes, a misdemeanor traffic criminal offense.
Oh, I'm sorry. Yeah, I apologize. I thought we thought I had something. So there is that one where she failed to appear. We're asking for a bond with the allegation she was not the operator of the car and think that a bond with a tether would be appropriate in this circumstance.
Okay, Miss Reed, are you employed?
No.
Why not?
I'm currently going through Michigan Works right now looking for a job.
Okay, that doesn't tell me why you're not employed. How long has it been since you've been employed?
Since I found my kid's dad dead in the bed, about 2012.
Since what? Ma'am? You are in court, so you need to carefully choose your words. So I didn't understand what you said about something from
I don't have a
2012.
job. You're asking me a question that I don't have a job. I just don't have a job.
Right, so you're choosing to just not work. How are you supporting
So
yourself?
how am I choosing not to work? I just told you I'm going through Michigan Works, working with them to find a job.
Ma'am? How are you supporting yourself?
I'm not right now.
And so you're 34 years old and you have not worked since 2012.
No, sure haven't.
So from the age of 20 to 34, you're just having other people support you?
This is irrelevant to this case. What's this for? I'm trying
Ma'am?
to get a job.
Excuse me. I've asked the question. I find it relevant
Okay.
because I need to ascertain whether or not you're going to be appearing back in court because you don't seem to have much of a connection to the area or any stability as far as financial stability nor housing stability. So those are factors that this court has to take into consideration in determining bond. So I find it very relevant, ma'am.
I haven't had no contact with anybody, so I'd have to figure that out.
I don't know what that means.
I didn't hear what you said.
She hasn't any contact with anybody, so she's got to figure it out. So I don't know what that means.
I assume that she has to figure it out, meaning how she go about getting the job
Well,
works, I'm assuming.
okay. And so, ma'am, how long have you been working with Michigan Works to obtain employment?
Just started maybe a week.
Okay. And so you don't have any stable housing. Whose address is this one on 12th Street in Ecorse?
Fine.
Yours.
Well, it's my address. I haven't changed it yet.
Ma'am, I said, whose house is it?
I used to live there. I have not changed my address yet.
Okay. Does somebody that you know still reside there?
I don't know. I don't know. I don't live there no more.
Okay, well, I'm going to cross that off because it's not a valid address. And ma'am, if you were to test right now, what's in your system?
Methamphetamines.
And how long have you not been feeling well?
Couple days.
Since before you were arrested or after you were arrested?
I've been here
I'm sorry?
since I've been here.
Well, it's possible. It may be withdrawal. That's why she's not feeling well. I don't know. All right, Detective, would you like to address bond?
Yes, Your Honor. As was stated on the record, she does have several warrants. A couple in the 33rd District Court, 2 in the 36th District Court. So I do have I have a lot of concern that she's going to appear back in court for this matter, especially since she's facing 3 very serious felony matters. So I'm going to request a $75,000, 10% bond to ensure that she comes back to court.
The court, after reviewing this matter, Ms. Reed's lack of employment, her lack of stable housing, in fact, quite frankly, she's homeless, as stated from her attorney, because she doesn't have stable housing. She goes from place to place. Given the nature of these charges, 3 serious felonies in this matter, and given Ms. Reed's inability to appear in court for prior matters, as she has a minimum of 4 warrants for her arrest, this court's going to order a $100,000, 10% bond, no surety, with the following bond conditions. You are not to possess or consume any alcohol or drugs unless prescribed. You are not to possess or have access to firearms or any weapons. And you are not to be released without GPS tether to the Wayne County Jail. There's no talking in court. All right, we'll see you back next week. Thank you.
Thank you, Ron.
Thank you.
Right this way.
All right, and then we will be on the record with Mr. Gagitis, I believe, next.
Oh, I don't think. Curtis,
Let's go on the record in the matter of the state of Michigan versus Steve Gagitis, 26241. And counsel, your appearance, please.
Your Honor, John Gopal, P 30758 on behalf of Mr. Gagitis.
Thank you, sir. Your name for the record, please.
Stephen Gagitis.
I'm sorry, Stephen, what?
Gagitis, Your Honor.
Well, I need him. It's not coming through very well. Sir, if you can try it one more time, please.
Steve Gagitis.
Gagitis. All right. And so, counsel?
Your Honor, as to the arraignment, he stamped the charges and waive a form reading of those charges, asked us if not guilty.
The court will waive the formal reading. Sir, you have the right to have an attorney. If you're unable to afford one, you may have one appointed to represent you. And in fact, you've had an opportunity to speak to an attorney today. Is that correct?
Yes, Your Honor.
The court will sign the petition order for appointed attorney for felony matters. And you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes, Your Honor.
The court's entering a plea of not guilty on your behalf, scheduling this matter for probable cause conference on March 5th,
8:45.
8:45 a.m. And counsel asked to bond.
Mr. Bond, Your Honor, Mr. Gagitis is 47 years old. He is gainfully employed at subcontract in Riverview. He is single. Your Honor, he does have prior contacts. In fact, there is also an habitual fourth, I believe, on this matter. We are asking for a charge with possession only. He is the co-defendant with respect to Ms. Reed. Feel that, Your Honor, a minimum bond in the area of 5,000, 10% is sufficient to affirm that Mr. Gagitis would appear. My understanding that he has raised major concerns regarding this. I've explained to him the purpose of today's proceeding and that his issues or his concerns would be raised at the next level or once attorney has been appointed out of the third precinct, out of the third circuit.
So let me ask your client a question, because I think before we go any further, I need to understand the status of his matter from Lincoln Park. Sir, are you currently out on bond?
Yes, I am.
And so what are you out on bond for, sir?
Felony charges in Lincoln Park, county firearms, all kinds of shit. See no language.
Sir, we are in court, so choose your words a bit more carefully.
I didn't mean to say that like that. I'm sorry, man. A whole bunch of matters around.
Right, felony, possession, controlled substance.
Yeah.
I'm sorry?
I'm sorry, I've got a lot of stresses, but I've had a little bunch of nervous
Well, sir, these
breakdown.
stresses all seem to be brought upon by your own actions, but
Actually,
the
the
court,
person came to the house where I got all these charges for. So I was sitting at home and it was brought to me. Somebody came to my house and something happened. And I'd rather not talk about it over in court. It's a long story.
Okay.
But I was sitting in my house minding my business when all that stuff happened. And the guns were his. So, and he got shot.
sir, just so you know, I mean, I speak pretty quickly, but you're speaking very quickly and I'm not able to understand 3/4 of what it is you're saying, other than you were at your house and then something else and you don't want to talk about it. So what I'm showing that you're on bond for, sir, is felony controlled substance, manufacture, delivery, ecstasy, MDMA, felony firearm possession by a prohibited person based upon your convicted felon status, and then felony firearm second offense notice. There may be more. I don't know. This is what it's showing here. Then I also show
Cause he didn't charge me with that one though, so he came to my house, I didn't do nothing to him.
Sir, I cannot understand what you're saying.
I'm
Can you,
please shoot me, man. I'm
Can you
not in my right
please-
state of mind.
can you please speak louder if you want to speak to the court? I need you to speak up because I'm not understanding what you're saying.
Nothing, Your Honor, I'm sorry.
Okay, that I can understand a little bit better. Sir, what about your matter from February 11th that shows assault out of Lincoln Park? Are you out on bond on that matter also?
Can't have no assault out of the important. This is domestic violence.
What was that?
It was domestic violence, I thought.
Okay,
Well,
well, you out on bond on domestic violence?
Homeless, back into my house and she caused all this mess for me, yeah, that one.
What? Sir, I just want to know, are you out on bond, yes or no?
I say yes.
Okay. So I can assure you it will not be a $5,000 personal or 10% bond counsel. Sir, who do you live with at your home on Fort Park?
Well, I got kicked out of my home, I brought my homeless baby mama back into my home and she called and got domestic violence on me, so I'm homeless.
Okay,
Homeless baby mama kicked him out.
okay, thank you. I'm having a hard time understanding that. And what's the name of your child's mother?
Tiffany Baldridge.
Okay, so you don't have a place to return to either. If you're at a test right now, sir, what's in your system?
Our test right now is on my system.
Yes.
I'm sorry. Couldn't tell you that. Don't know. Test me and find out.
Well, I can see why you and Miss Reed hang out together, but okay.
I'm just,
So-
I'm going through enough stuff. I don't need to question. This is a minor. They put me out the car illegally anyway and searched me. I don't got no warrants, so I'm about to beat this. So after I beat it, then what?
What is he
I don't
saying?
understand.
Chief, I assume, Your Honor, and we all know what happens when I assume something. He is alleging that the search was improper based on his opinion.
Okay,
I've explained to him that this is not the venue to contest that improper arrest. The next step is where those matters would be addressed.
okay. Sir, what is your bond in the 25th District Court?
You're right. I'm been through too much stuff. My mind, I'm just been through too much stuff. I don't even remember. I'm sorry. I'm trying to put my behavior also. I've just been going through too much. I'm at stress level. I asked them to take me to the hospital yesterday. They wouldn't take me. So I'm not feeling good. I'm going through too much stress. I had a breakdown or something.
Sir, did you have to post bond or have somebody post bond or do you have a personal bond? That's my question.
All the above. Both.
All
I
the
put
above.
nobody
Okay.
in that place.
Okay, all right. Detective, would you like to address bond?
Yes, Your Honor. Mr. Gagitis is on a GPS tether with the Wayne County Sheriff's Office. He also had a warrant for driving without a license out of the MSP Metro South Coast. These offenses are very serious, especially with the habitual. So he's facing serious time and he continues to reoffend even on tether. So I'm going to request a $100,000 10% bond.
All right. Well, the court will note that Mr. Gagitis is charged with possession of controlled substance, that being methamphetamine, which is a 10-year felony if convicted. Given Mr. Gagitis' habitual offender fourth offense notice that he is facing up to life in prison as the primary offense has a penalty of 5 years or more. Based upon that, combined with Mr. Gagitis's homeless status, combined with Mr. Gagitis's current bond situation in the 25th District Court, which is a felony delivery manufacturer charge, and now he's here in this court on a possession of controlled substance charge, another felony matter. And the court will also note that Mr. Gagitis is on bond and it's a felony firearm, and that Mr. Gagitis' co-defendant is charged with possession of a firearm as well. And so
Oh,
for
okay.
all of those reasons, stop talking, sir, please. For all of those reasons, this court's going to order Mr. Gagitis held without bond, given his current probation status, as well as the other matters that this court stated.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. And based upon Mr. Gagitis's pending warrant, the warrants as well for his failure to appear. Off the record. We'll see you back March 5th. All right, let's go on the record in the matter of the state of Michigan versus Tracy Anderson, 26246. And then we also have the city of Wyandotte versus Tracy Anderson, 26210. So on the felony detective, I'm going to have you hit unmute, please.
Do you hear me?
Yes,
Do you hear me? Okay.
yes, thank you. And detective, your name for the record.
Detective Geiger, Wyandotte Police Department.
Please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And counsel, detective, you may proceed on the warrant.
On February 26, 2026, approximately 4:40 in the morning, Officer Stathis was traveling eastbound Emmons Boulevard when he observed a white 2012 Ford Fusion traveling southbound 2nd Street. The vehicle stopped well past the stop sign at Emmons Boulevard, blocking the crosswalk. The vehicle briefly turned westbound Emmons Boulevard, then southbound Edcliff Court. Officer Stathis immediately recognized the front seat passenger as having an outstanding warrant for arrest locally in Wyandotte. Officer Stathis activated emergency lights and conducted a traffic stop on the vehicle as it pulled into the driveway at 215 at Cliff Court. Officer Stathis made contact with the driver at the time, identified as Tracy Anderson, and asked for a driver's license as well as the passenger's ID card. Officer Stathis asked Anderson if there was anything illegal inside of the vehicle. Anderson stated she did not own the car, nor that she was unsure. Officer Stathis asked Anderson for consent to search the vehicle. Anderson gave consent to search the vehicle. Officer Stathis asked Anderson to exit the vehicle, and she complied. Anderson then consented to search of her person as well, but nothing was located. Officer Stathis had Anderson stand at the front of the vehicle while he asked the passenger to exit the vehicle, who also complied and exited. This individual was also consented to a search of the person, and nothing was located. At this point, other officers arrived. Officer Stathis searched the vehicle and located a clear cellophane baggie, corner tied off, containing a white rocky substance, which was later identified as crack cocaine. And this was located underneath the driver's seat where Tracy Anderson was seated. It was subsequently field tested positive for the presence of cocaine. Ms. Anderson has a prior felony conviction in Third Circuit Court on January 29, 2022. Felony controlled substance, possession, cocaine, heroin, less than 25 grams, pled guilty. That's it, Your Honor.
All right, thank you. Upon examination of the complaining witness, I do find that the offense charged was committed. There's probable cause to believe defendant committed that offense. And counsel, your appearance, please, on both matters.
Thank you, Your Honor. Your Honor, John Goldpaw, P. 30758, appearing on behalf of Ms. Anderson on file 26-246, as well as 26-201. As to 26-246, Ms. Anderson would stand mute to the charges, waive a formal reading of those charges, as concluded in our open meeting.
All right, ma'am, your name for the record, please.
Tracy Anderson.
Okay, we've been seeing a lot of you this week.
Yeah, sorry.
All right, the court's going to waive the formal reading. Ma'am, you do have the right to have an attorney. If you're unable to afford an attorney, you may ask for one to be appointed to represent you. Do you understand those rights?
Yes, ma'am.
And you have in fact spoken to an attorney today, correct?
Yes.
The court has also signed the petition order for appointed attorney for felony matters. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, ma'am?
Yes, Your Honor.
Okay. As to the City of Wyandotte case, the court's going to
Yeah, and Your Honor,
also waive the formal reading,
and I-
enter plea of not guilty, schedule this matter for pretrial on March 11th. And yes, you're not the attorney of record that day, counsel, but you are the attorney for arraignment purposes only.
I understand, Your Honor.
Oh,
I would put my on the record, she was defending me for the charge.
yes, you did. You already did that.
Oh, I didn't.
You did, yes.
Thank you.
And let me just state this, I'm not sure, I don't recall, counsel, if yesterday you represented Mr. Campbell in his sentencing.
No,
Okay, or if you represented Mr. Zamet on Tuesday. Nope, I think that was Mr. Shemke.
no, I didn't.
And Miss Jill,
Yeah.
but you did represent Miss Jill something or other today, Jill
Ms. Simpson.
Jill Simpson. So, Ms. Anderson, I know Ms. Simpson was a passenger in your vehicle, correct?
Yes.
Okay, and so counsel, do you want to go over any potential conflict for arraignment purposes?
Your Honor, we didn't even mention Ms. Simpson with respect to that, other than did I know her or did she know her? I realized that I did do matter yesterday, I believe it was, or I did do her proceedings. No, that was earlier today. I apologize. Simpson on her arraignment. We did not get into the details. There was no showing of any favoritism. All we are doing in that particular matter is arraign her. For her pretrial of, I believe it's the 18th. It may,
Okay.
no, it may be the 11th as well, Your Honor.
That's the 11th.
It is, and, which again, I am carrying a record of, and I will not be here on that date,
Okay,
but there was no conflict.
all right, and
Is that correct? In our discussions regarding the misdemeanor, I didn't treat you any differently because I did Miss Simpson's arraignment earlier today. Did I?
No. You're
Okay.
fine.
all right, and so, as to, the pretrial was set this for March 11th at
9:45 a.m.
Can I ask you questions?
just one moment, ma'am. And then the probable cause conference on the felony matter, March 5th at
Ten 45.
all right, thank you. Ma'am, what's your question?
Now I have a job and I have eviction coming up, as you know. I need to be able to, is there any way to get my bond lower, if not a personal? I live in the city of Wyandotte.
Ma'am, I would suggest stop talking, let your attorney do the talking right now.
Right,
Yeah.
okay.
As the court is well aware, there are a lot of problems from her, court problems that are not all really criminal. She does have an eviction proceeding that was in court on
Tuesday, yes.
Tuesday. The court, in fact, I believe mentioned that when we arraigned Ms. Simpson. She's 55 years old. She does have a drug problem. She readily admits that. For a number of years, she was sober, for lack of a better term. She has, it's alleged now that she has relapsed, or at least has had, she started with possession of a controlled substance. The medication, 55 years old. She's single, has been involved with the same gentleman was Mr. Campbell, I believe.
Right, Mr. Campbell was pretty upset that you didn't post his bond. He was at his sentencing yesterday, and he was surprised that you hadn't yet come in to post his bond. So,
I was in court for the eviction.
ma'am,
I talked to
you were not in
Matrimony.
court all day because on that day, Mr. Zamet was upset that you still had his vehicle and he wouldn't be able to contact you to get his vehicle back. So you have a few people that are a little bit upset with you, ma'am. And you were not in court all day on Tuesday. You were in court for a very short while. So
2 hours.
that's not the reason why you didn't post his bond, but please, hold on, ma'am, Counsel.
This is why bond down matters. She is employed. She has lived in the Wyandotte area for 5 years, and she has been employed as a home health care through the state for the last 3 years. We are asking for a bond, which is commensurate with the charges, and also one that she can make so she can get back into treatment. She knows that she has a drug problem. As I've indicated, she was sober for a number of years, which resulted in a relapse.
All right, well, ma'am, tell me, are you out on bond in your matter from Lincoln Park?
Yes,
Okay, and for what are you on bond, ma'am?
paraphernalia.
No, I don't think it's only paraphernalia.
In possession.
What's that?
And possession. I've been going to meetings and
Right, and possession. Possession
Yeah.
of, the charge is possession of what?
narcotic.
Right, okay. And you're out on bond in that matter, and then you are arrested on your another possession charge on February 14th in the city of Wyandotte. And yet, and then you posted a personal bond in that matter, or you had a personal bond from the police department and were released on Sunday. And then lo and behold, you're arrested this morning for yet another possession charge. This time, another felony. And you have Miss Simpson involved now, Mr. Zamet, and you have Mr. Kimball. All of you are all involved. And those are all the same names that keep popping up all week.
Apologize.
And so, ma'am, where do you work? Who's Alicia Higgins?
The lady I take care of.
And is that full-time, part-time? What is that?
Full time.
And so you're also receiving disability, Social Security disability?
Yes.
Okay. And so what's the nature of your disability, ma'am?
I need a hip replacement.
You get disability for hip replacement needing that?
And I'm going to get one. So as soon as I'm done with it, I'll be off Social Security.
Oh, okay. And so the lady that you take care of, ma'am, what is it you do for her?
Light housework, cooking, driving her to appointments.
Well, it seemed to me that you could still work. If you can take care of this lady, you could still work.
Yeah.
But yet you're not. You're receiving disability benefits. When is your hip replacement surgery scheduled, ma'am?
Next month.
Next month. Oh, okay. And who do you live with at the home, ma'am?
Keith Campbell.
Who?
Keith Campbell.
Okay, well, all right, well, just so you're aware, the attorney that represents your landlord also heard the drug charges that were going on when Mr. Zamet was being arraigned, so you may end up with some other type of notice and not even be able to have your 2-week adjournment for rental assistance. I don't know, but because the statute does allow for immediate eviction if there's drug activity, so I don't know if that's what the attorney is going to do or not. In any event, ma'am, how long have you been receiving disability?
A year.
And where did you
Yeah.
work before that?
I worked at Home Depot, couple of different places. Texas Roadhouse.
But you've been taking care of Miss Higgins for 3 years?
Yes,
Okay. Have you ever failed to appear in court for any reason, ma'am?
no, ma'am.
All right, Detective, would you like to address bond?
Just due to the nature of this case, no illegal drugs or alcohol, no drugs, no illegal drugs, only drugs allowed if they're prescribed. In this incident, she had an Adderall. We're still looking into that to see if she has a prescription for it. And then due to the fact that it's habitual offender second notice, I would request at least a monetary bond to keep her or short presence in court, 10,000, 10%.
Okay,
Excuse me, Your Honor, not to argue, she's not, there's not a notice for habitual. She's technically it is, but it's only because of the nature of the crime. It's not an habitual offender notice, but it's a second possession of control.
second or subsequent offense known as double penalty, correct?
So it doubles the penalty. The original penalty, I believe, is 4 years.
Right,
I just want to keep the record.
correct, okay. So, ma'am, you want treatment?
Yes,
Great, we're going to help you with that. So, here's what the court's going to do. On 26246, the court's going to order a $50,000 personal bond. You are not to be released. You are not to be released. You are to be only released to treatment through the Wayne County Jail. Defendant to be tethered to treatment through the Wayne County Jail.
how do I fix my eviction and take care of my job?
I don't know, man. You have to figure it out. Because you were on a bond. You're on bond for the same thing that you're charged with now.
I know.
So you're a danger to the community as well as yourself. So this way you're going to be in treatment. As you've indicated, that's what you're asking for.
Yeah, but I don't want to lose my house either.
Oh, ma'am. Treatment seems to be something that should be a priority for you right now.
Yeah, but when I get out, where do I go? I got two.
Mr. Campbell, I think, was just released yesterday. I think that, I think I did that. I think that I gave him, time served, I think is what I gave him. And, actually, bro, I'll let you know, just to put your mind at ease. Can you look him up from yesterday, please? And then while she's doing that, 26201, the court's going to order a $10,000 personal bond to be tethered to treatment through the Wayne County Jail.
Your Honor, you indicated that she was out on bond.
25th District Court for another felony possession charge.
I apologize. Okay.
It's not a felony. It's not a felony in Lincoln Park.
Well,
We know that.
it shows that on the criminal history. So either way, ma'am, felony or misdemeanor, it's still a bond.
Right.
Thank you. That's what I was, I didn't see that when I was.
Yes, Judge, you did do 10 days jail credit, 10 days, and then fines and costs.
Okay, so Mr. Campbell, unless he has a hold somewhere else, will be released so he can maybe communicate with your landlord. I gave him 10 days jail credit for 10 days. So perhaps you can speak to, perhaps he can speak to the landlord for you. I don't know.
Can I make a phone call to him?
There's a condition of you not to contact him. So whatever the police department's policy is over there with phone calls. Okay, we'll see you back on March 5th and March 11th. Thank you. Have a good day.
Thank you, Your Honor.
All right, let's go off the record. Oh, no, wait, yep.
I can see it. They
let's go on the record in the matter of the City of Wyandotte versus Garrett Pastulka. 26242 A and B.
Good afternoon, Your Honor, John Goldport, P 30758, on behalf of Mr. Local Police. On the record.
Sir, your name for the record, please.
Here, Stalka.
Okay. Pastulka. All right, and counsel?
As for the arraignment, Your Honor, extending to the charges, waiver upon reading of those charges, asked for a plea of not guilty yet.
Court waive the formal reading, enter plea of not guilty for purpose of the arraignment scheduled for pre-trial March 11th. At 11 a.m. And counsel as to bond.
Your Honor, as to bond, Mr. Pastulka is 34 years old. Is that correct, sir?
36. I'll be 36 next week.
36. I apologize. 36 years old, Your Honor.
Well, he'll be 36 March 1st. Sunday will be his birthday.
No. Yeah.
Happy birthday in advance. Your Honor, I was 36 years old. He is gainfully employed at Captain's, has been there for 9 years. He's single, he lives by himself. However, Your Honor, he's put his correct address on their advice rights. He does not reside at Allen Point Drive. Where do you reside? I'm sorry.
Hold on. The correct address is on the advice of rights?
Correct.
Okay, I'll change that.
Yeah.
I'll change it on our end.
Corner on the
Hanford, yes.
rights.
Okay, counsel, before we proceed, I just need to ask a question. Mr. Pastulka,
Yes.
were you working Saturday night?
This previous Saturday, yes, I was.
Okay, and were you back and forth between Captain's and Size?
Yes, I worked the party, unfortunately, yes.
Okay, so counsel, I just need to indicate that there was a 21st birthday party celebration and I was there. It was for one of my children. And so your client was back and forth between Size and Captain's. And so I don't know that I necessarily had any conversation with this individual. I may have asked about the appetizers that were supposed to have been out. I don't know, but I don't know if that's any,
No, I don't think that that would be any impediment on you handling this matter, unless you were out partying with Mr.
I was not. In fact, I had water the entire night.
I'm sure you did, Your Honor. I just like to bring that.
Not even Mexican, actual water.
I understand, Your Honor. I don't believe that there'd be any conflict, Your Honor.
Okay.
You
Mr.
aware-
Stalka, do you have any objection to this court continuing?
Proceeding?
No, we didn't have any contact, so we're okay.
Okay. I did not order any drinks from you, did I?
Well,
Not,
No, I did not.
it's legal to drink, Your Honor. It's just not legal to drink to excess and then drive a motor vehicle.
All right. Okay, so. Okay, and so, all right, so I will change the address here.
Thank you.
All right, and counsel? You were continuing.
He's, as I said, 36 or will be 36. He lives by himself. He's not on probation. He's not on parole. There was a prior alcohol matter impaired back in 2013. We're asking for a personal bond or minimal bond under these circumstances. He understands that, he's charged with these charges, that drinking and driving is not the way to go. And he is here to accept responsibility, well, eventually to accept responsibility. We believe that a personal bond would be.
Okay. Sir, how long have you worked at Captain's?
It'll be 9 years on the 17th.
Okay. And have you ever failed to appear in court for any reason?
Only once because I did not receive the notification in the mail because I changed my address.
Okay.
And was that back in 2013?
That was back in 2013.
You did eventually appear and that matter was resolved, correct?
Yes, the matter was resolved. They took care of everything.
All right, so, have you since cleared that up, sir?
Yes, everything's cleared up from my previous charges.
Okay,
And I will be responsible for this one as well.
all right, well, it's showing that there was a bench warrant that was issued from the one from 24th District Court in 2017, so that's why I just wanted to clarify that it's been cleared up. Although it says that your status, your driving status is not valid.
That is correct.
It's
My-
expired.
my-
All right, well, it seems to have been expired since 2018.
Yes. That's from the Secretary of State had taken that away from me and I have not cleared that up.
Well, then you cannot drive, sir.
That's correct, yeah.
Right. And so if you were to test right now, what is in your system?
Just the alcohol, maybe marijuana.
Okay. And do we know when the last time your client was tested? I know he was a 0.25 this morning.
Yes.
0.255.
I think he was tested approximately 2 hours ago and was down to a 0.11, I believe.
Okay. Sir, do you feel as though you're still under the influence of alcohol?
No, ma'am.
Okay. Do you have a valid prescription for marijuana?
I do not.
Not
correct.
sure. He does not have a medical marijuana card. I've explained to him that as a term and condition of bond, regardless of everything else, that no, only drugs with a prescription. And that if he were to get a medical marijuana card, he would have to get that from his provider, not through his regular doctor and not through, Happy Harry's medical marijuana shop. Is that correct, sir?
You know somebody's gonna come up with that name now for medical marijuana shop, right? All right.
Trademark it, Turner. Is that legal trademark?
All right. So here's what the court's going to do. The court's going to, based upon the prior failure to appear, the prior alcohol related conviction, the high level of this matter, the court's going to order a $7,500 10% bond with the following bond conditions. You are not to operate a motor vehicle, sir, without a valid license.
Okay.
You are to not possess or consume any alcohol or drugs unless prescribed. You are to participate in random testing. So upon your release, sir, you'll have to contact probation to set up that random testing. And then you are not to be released without an alcohol tether through the Wayne County Jail. Given your client's line of work, the court will allow your client to do a sober link where he can test. It'll be 6 times a day.
I know.
So there's a device you have to test, you have to give a breath sample, sir. So that I don't have to hear if there's a violation, oh, somebody spilled beer on my leg,
I understand, John.
okay?
Your Honor, does that have to be through the Wayne County Jail?
Yes. That way, if there's a violation, he'll be taken into custody immediately.
Yeah.
Yes.
As opposed to, just was asking, Your Honor.
Okay. We'll see you back on March 11th. Thank you. Have a good day.
Thank you, Your Honor.
All right. Let's go off the record.
Let's call the case people versus Ashana Barrett.
Alexander, on behalf of the people, Your Honor.
Judge. Public defender on behalf of Mr. Barrett, who should be approaching the podium. Please state your name for the record.
Shawna Barrett.
Thank you, Judge.
Sorry.
Just get a PR. I don't.
You should be in receipt of a green sheet, Your Honor. That's
I am.
German,
You
but-
aware of the violation?
Yes, Judge. There is a bond violation in this file, and I know that the court would want to address it, Your Honor.
Yes.
Thank you, Judge.
This is the DV case and she was in contact with the protected party.
Yes,
I'm not even sure how, after arraignment, she got a PR.
I was not there either, Judge. I don't know either. All I can say on behalf of Ms. Barrett is that obviously she apologizes for the not following the court's order. And she has an excuse, but obviously it doesn't justify her being in contact with the protected party, Judge. I did tell her that Your Honor was not going to be happy with the facts of the violation and what the court was likely going to want to do based on her being in contact against the court's order. She still showed up to court and she did not run or leave this morning when I reiterated that she may not be going through the front doors today. What she wants me to let you know, Judge, is that obviously she has a small child, a 2-year-old son, and she has financial difficulties. I believe that she was in contact with the protected party because that person had a car and it allowed them to do DoorDash together so that she could make money to buy diapers for her child. She apologizes for not following the court's order, but that is an excuse for why she did not do so. And she's asking Your Honor to consider giving her another opportunity. And she says she will not make that mistake again, and she will follow the court's order next time. But she doesn't have any other justification for why she violated the court's order, other than she was trying to provide for her child, and she has no other family or support here, and she needed to use that vehicle. That's how they were stopped, Judge. The vehicle did not have a proper license plate on it. And I believe that's how they were stopped in the vehicle while they were doing DoorDash. And that's how she was brought back in the car.
Your Honor, I have concerns with the DV case the court stated, and there's no contact, means no contact. I also have concerns that the reason for it was to take care of the child. The child was at the bar at the time of the DV incident. So frankly, I think there should be a no contact with the child, given that the child was in the car for the part of the event as well. But no contact means no contact, no matter what the excuse is. This is a domestic violence charge, a felony charge. So at this point, I would ask for a remanded due to bond violation.
I'd ask the court not to put a no contact order against the 2-year-old child. Obviously, that child would not be testifying in this case, and there would be no jeopardy to the child in this matter. But I do understand the people's request for a remand based on the
I won't add that condition unless I have additional information regarding the no contact with the child, or if there's some type of CPS, something, but I'm going to adjourn the probable cause hearing to March 5th, 2026, 9 a.m. At this point, given the violation, defendant's bond is hereby ordered to revoke. Defendant's remand is lifted.
Come back and behind the table. Thank you, Judge.
Thank you. Court calls case People versus Denard Gray.
As and on behalf of the people, Your Honor.
Yeah, for who?
Mr. Griggs, Bernard,
That,
Gray, I was so close. Your Honor, I'm sorry. I was talking to another client about an offer that just came through. My apologies.
Sir, your name? Thank you.
Your Honor, at this time, we are going to be asking for an adjournment of the matter
Why
to,
are you yelling at her?
because I was talking.
Why are you yelling at
I
her?
wasn't
So,
yelling at her. I was
yes, you
celebrating
were.
her.
You were like demanding that she do something.
Oh,
Why were you doing that?
I was celebrating her independence, Your Honor. That's all. Sorry. You're asking for a brief adjournment of this matter so we can see if we can negotiate and or mitigate this down a little bit for my client. Your Honor, we'd also like to address bond when appropriate.
Okay. So you're looking for a brief adjournment and Ms. Zenda has risen,
Oh, no.
which means we're probably
She didn't mean
we're gonna get a bond thing anyway.
She didn't
So
mean to stand up.
Ms. Zenda, I'm gonna let her roll. Go ahead.
Your Honor, it has come to my attention that Mr. Gray has made 4 calls to the victim since his arraignment. In these calls, he states things asking her, can you not leave me? You promised me to stay with me. Stop listening to her as in her mom, who was also mentioned in this case, and just tell her the truth. When we get to court, can you tell him to drop it, or that you can just tell him the truth? So at this point, I'm going to be asking for his own ministry vote. I'm also going to be re-requesting our original bond of $500,000 cash surety for this case. This case involves 3 separate incidents of domestic violence with this victim, including the defendant taking her phone and even not talking to anyone. She wakes up to go get her phone. He then catches her trying to get the phone, punches her in the face numerous times. Another incident, he was controlling her eating and sleeping, and an argument began. He told her she had to stay in her room, but she left, and then he beat her for leaving the room. He hit her in the head and the body about 10 times with his fist. He also hit her all over her body with a broom. He also punched her in the eye multiple times. She then fled to her mother's house to go to the hospital. She had a black eye, memory loss, bumps and bruises all over her body, cuts and bruises on her nose, eye, cheek, bruise on her lower back, a concussion, contusion of her face and ribs, and back pain. Her mother, who she fled to, also made a report with Inkster Police for him sending her a picture of a gun with threats associated with that. If I can just stop, please don't come to my house. Please give me my wife back. Don't let them people think I won't kill them for coming to my house. I'm a man of Yah. So at this point, I'm going to be re-requesting our original bond. The victim also mentioned in the report briefly other possible strangulation incidents and other instances of the defendant possibly putting a gun to her head. So there could be also more charges incoming depending on conversation with the victim. So at this point, I don't believe that the bond as set with 50,000 cash surety is appropriate. I would be re-requesting our $500,000 given the facts of this case, and that he is continuing to violate his bond and the no contact order, and would also be asking for his home.
Respond.
Your Honor, as far as the text messaging with the weapon, that was in a direct response of them threatening him and threatening to come to his house. So, and she even read that, tell them, don't come to my house. If they come to my house, I will defend myself. So, and that's what those text messages say. They were not a reach out to threaten anyone. They had been threatening him. And this was his response to those threats. He could have done better in how he chose to deal with that. And we've discussed that, but the threats in that matter were more like a self-defense. He was not trying to do anything. He wanted them to leave him alone. As far as those go. Your Honor, I spoke to my client yesterday and I was exceptionally clear that he is, even if it is just to tell someone that you love them and that you're still husband and wife and things of that nature, he cannot reach out to the complaining witness because the court stated that that is something he cannot do. Your Honor, I do want the court to know he has a stable home. He has a job. He's a chef at Villa Park Ridge. The complaining witness lives with her mother down in Inkster. He has dogs who are currently at the shelter and they're about to be turned over for adoption and or euthanasia, depending on the status. He has been on his own since he was 17 years old. He doesn't have anyone else, it's just him. But he doesn't want to lose his home, he doesn't want to lose his job. He doesn't have a car, so he can't get to Inkster. I explained to him once again, Your Honor, that he cannot have any contact, period, with the complaining witness if released on bond to his home. My client has assured me that he will not be making any contact with the complaining witness.
And your just want to know again to the court, the calls weren't just I love you, it was come to court, do what I told you to do, tell them that that's not what happened. A direct quote, when we go to court, can you tell them like to drop it, or that can you just tell them the truth, bro? Later asked her again in another call, can you just please just do what I need you to do, okay? So it's not just love, it's interfering with the criminal process here. So I have concerns that he cannot follow court orders to not contact the victim and interfere.
Having heard the argument in this case, I'll adjourn this matter out to March 12th, 2026, 9 a.m. I will grant the request of the people finding an abuse of discretion to accept the bond where it is. His bond will be increased to $500,000 cash surety. Defendant's phone privileges as well as texting privileges are hereby ordered revoked.
Thank you.
Thank you. Court does call the case, the people versus George Lum.
I'll take a look at the people.
Joe Simon on behalf of Mr. Lum. George, state your name when you get up here. George Stewart Lum.
All right. Go to the plea form.
Yes, Your Honor.
All right. Court has before the plea form that indicates that the defendant would be pleading guilty to an added count 2 of abandonment cruelty to one animal involving an animal's death, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. The prosecutor will not object to defendant's request of no upfront jail. That's the court's full understanding.
Did you put the deferred on there, Mr. Chablowski?
No,
I do not have deferred.
I am sorry, that is an error, and I apologize for not catching it. I don't object if Mr. Chablowski approaches to an amendment. Thank you, Your Honor.
What is the issue of the deferral is that it would be deferred sentencing?
That's correct. And I explained to my client that you won't be the sentencing judge, and that's ultimately up to the other judge, but yes, that's an agreement that the people have made.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth self you got?
I do.
State your name, please.
George Stewart Lum.
Sir, it is this court's understanding that you're going to plead guilty to the charge of abandonment or cruelty to an animal involving one animal and involving an animal's death. Is that correct?
Yes, Your Honor.
All right. That is a misdemeanor. It's punishable by up to 1 year incarceration, $2,000 fine plus court costs, and up to 300 hours of community service and any other psychiatric care the court would deem necessary. You understand that, sir?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
How do you plead? Yes. Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Right? You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Yes?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of May 27, 2025, at the location of 608 Spring Street, in Ann Arbor, Washtenaw County, state of Michigan, what did you do on that date that makes you think that you're guilty?
I try to
burn a groundhog.
You tried to do what?
Burn a groundhog.
That was trapped in a cage,
Yeah, it was trapped in a cage.
and you tried to kill it.
Yeah, I tried to kill
By doing what?
it. Poured gasoline on it, tried to kill it.
He ignited.
Poured gasoline on a groundhog that's in a cage and then lit it on fire?
Yes, Your Honor.
Oh, Lord Jesus. You did that intentionally?
Yes, Your Honor. Should I explain?
Sir, you understand that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, I guess I should ask one question. The groundhog died?
The DNR eventually put it down. Oh, so not from my client's action, but yes. What he did.
The DNR put it down because the animal was suffering.
Exactly.
All right. Sir, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
And that you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are there any other promises, threats, or other inducements which have led to this plea?
No.
No, Your Honor.
And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes.
Yes, Your Honor.
Accept the defendant's plea to count guilty to count 2. Count 1 is dismissed. Pre-sentence and investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
March 27th at 8:30 a.m.
March 27, 2026, 8:30 before Judge Perry.
Thank you, Your Honor.
Wait. Yep.
Give me some darn gasoline. I'll put you in a cage. Oh, I shouldn't have said that out loud, should I? Okay, I'm done. And I'm not a big groundhog fan, but damn.
Can I approach very quickly? With Mrs.
Anything about Sonic? No.
Okay.
The hedgehog, groundhog, hedgehog, doesn't matter. Minding its own business. Court does call the case, People versus Dion Lyons.
Yeah, is that on behalf of the people, Your
Did you
Honor?
call him out?
No.
Oh, and good afternoon, Your Honor. Attorney Kevin Bassan, P 71061 on behalf of Mr. Dion Lyons.
All right. Lyons.
State your name for the record.
Dion Lyons. All right. Folks, go ahead.
And so, Judge, today is the daytime technically scheduled for a violation hearing. Mr. Lyons has been advised of his right to a hearing. But this time, Judge, we waive that right, Judge, and decline having an actual hearing in this particular matter in terms of having the witnesses testify in terms of bond. Is that correct, Mr. Lyons?
Yes, sir.
You gotta speak up, though.
Yes, sir.
So we would still like to address bond, Judge, and procedurally still set this matter for a preliminary exam.
All right. I do this. So you have all the discovery.
I do, Judge.
People have their witnesses available the 10th.
We'll do our best, sure.
And Judge, the 10th works for me, Judge. I would just ask if possible, Judge, is there any way that this could be scheduled for the afternoon? Is that possible?
Can't do that.
'Cause I have an exam that morning, but
I can give you the 17th.
well, the only issue, Judge, his mom is scheduled for surgery on the 12th.
Got it. Yes, I remember.
And the only issue I have, Judge, is that the other date that you have, the 24th, is that I start a trial at 15th District Court on the 23rd. I start a jury trial on that date.
Who do we have on that? 10th?
The 10th, it's Judge Walsh.
See, I can't really set it in the afternoon. What? We don't. Okay. I'll do this for you on that count. I'll set a preliminary examination in person, March 10th, 2026. At what time do you think you'll be available?
1, 2 o'clock will be fine, Judge.
I'll set it at 1 p.m. I'll put that before me.
Thank you.
And since I'll be in the building anyway, and that way if the other judges have left, then I'll just take it.
Thank you.
Okay. All right, Esteban.
Esteban, Judge, so I know the court had technically revoked my client's bond if he tested positive for opiates. He's been in custody for a little over a week now. I've had a long talk with my client, Judge, including his family. Judge, he admits that there's an underlying substance abuse issue with opiates, and it's been kind of long standing. I would note that his last test was negative. I can assure the court, since he's had a week to completely dry out with no access to any type of substances whatsoever, that will continue. My client knows that he is to test clean, test negative, and stay clean. He's even willing to work with his family to get any type of substance abuse treatment that he may need. Judge, I can assure this court that there will be no more positive tests for anything, opiates or anything of that particular nature. I think being locked up was a wake-up call for my client, and I truly think he's trying to do the best he can to take steps to stay clean, not only for himself, but for his family and for his daughter. And so with that being said, Judge, I would ask the court to consider reinstating his bond, giving him one more opportunity to prove himself to the court that he can stay clean and take advantage of any type of substance abuse help that he may need to do so, you know. And I would also note that apart from testing positive, that on not the last test, but the test before, that technically there's been no other bond violations whatsoever.
So, yes, from a technical standpoint, he's admitting to the violation. Then
yeah, and he's admitted to the violation. Correct, Judge.
Young man, anything you want to say before I rule on that? Let me ask you something. Why do you think I locked you up when I saw these results?
I admit I have a problem. So I have a problem, and I admit to it.
Yeah, but there's a deeper reason why I did that.
I don't know.
You don't know? All right. I saw your mother sitting back there. I knew she was here. She's been with you when you come down here, right?
Right.
And the problem with what was showing up on your test, both of those things on those tests can't be true necessarily. All right. What it tells me is that, yes, there's a huge underlying problem. The issue for you is that there are drugs being taken that counterindicate or counteract each other. And part of the reason I put you in jail is so you don't end up dead. Because if you take those two things at the same time, that's it. And then mom doesn't have a son to sit there and wait for. That's why I did it. All right. I did it because I believe, despite anything you've done or anything like that, your life has value. And that you're trying to fight something that's hard enough as it is, right? But you're doing it in a way that can end up killing you. Get me?
Get it?
You know, young man, when you've probably seen it before, but when you got taken out of here, your mom kind of looked down, she broke into tears, but she was also, I know, saying that prayer that no one else but a mother could say for her son as you walked out. So consider that blessing that you have. You got me?
Got it.
He's admitted to the violation. I'm going to sentence him to 7 days credit for the 7 days that he served. I'm going to grant your motion. I'm going to reinstate his bond, his previous bond, with all of its conditions, including testing. So you're going to continue to test. Young man, I want him clean.
I will.
All right. Okay.
Thank you very much, Judge.
Thank you. And we'll see you on the 10th.
Oh, thank you, John.
Take care, man. Is that it for us?
Good afternoon, Mr. Wooster. This is Judge Middleton, and I'm going to arraign you on a case where you failed to show up for your pre-exam conference. The file number is 26190FY. Your attorney in that case is Mr. Paul Gibson. He's here with me at the courthouse. I asked him to be here for this arraignment. Also present is Mr. Gary Gabry from the prosecuting attorney's office. In that case, Mr. Wooster, you're charged with possession of methamphetamine and possession of appears to be cocaine. Date of offense was allegedly February the 5th. You posted a $15,000 surety bond. When released on that bond, you were set for a pre-exam conference on February 17th, and you failed to appear for that. The court issued a bench warrant and did a notice to start the forfeiture of your bond. I understand you got arrested on the 24th and have some additional charges pending. We're going to get this case back on track. I'm going to set the pre-exam conference in conjunction with your new case, which is, Paul, are you available next? It's short notice. It's next Tuesday, March 3rd, but that's when the pre-exam is in the new case.
Yes, I am available.
All right, I'll set pre-exam conference for 3/3/26 at 8:30. Set preliminary examination if needed for 3/10/26 at 1 o'clock. Mr. Wooster, you're bound over to circuit court on an earlier methamphetamine charge from July. I just lost your case. File number.
File number is 25-25820 FH, Your Honor.
Yes, thank you. Then there's this case, which is 26190. Then your new case is fleeing, eluding a police officer, assaulting and resisting a police officer, possession of methamphetamine, and a habitual offender. My inclination is to increase your bond from $15,000 to none. Just deny the bond. I also understand there may be a hold on you from Cass County. Mr. Gabriel, you got an additional input on that?
Yes, Your Honor. Obviously, I'm here because our concern that methamphetamine seems to be driving his criminal behavior. Even though he can post some money to get out on bond, he turns right around and gets back into the meth. And this case, the one that occurred on February 24th, has a lot of similarities to the one that occurred that's already up in circuit court. And that involves him deciding he's not just going to pull over and take his medicine, he's going to run. This was an extensive chase through the county by the sheriff's department. Speeds hitting up to 90, 85 miles an hour. Fortunately, no one was hurt, except he crashed his car into a tree and then ran and got tased. Clearly, he's a flight risk. He can't follow the court's instructions. So I think that, and I'm not sure, but I think maybe he was arraigned yesterday on that charge.
I believe that's correct. That's why the bond in that case,
100,000.
75,000.
Okay.
I'm inclined to do no bond.
Thank you.
Mr. Gibson, that may be a moot point. It does put some pressure on the prosecutor to resolve the case, but bond can always be amended either at the pre-exam, the prelim, or the circuit court arraignment. But in light of all the circumstances, bond is denied. We didn't end up forfeiting your bond because you got picked up again. So that $15,000 you posted with a surety company will just go back to them. But for purposes of this, both of your hearings are set for pre-exam conference next Tuesday. Mr. Gibson represents you on the February 5th case. Mr. Tim George represents you on the new case. And I don't know why they keep doing that. We've been working with the Indigent Defense Commission to appoint the same lawyer on the same defendant, but they're still working on that. Anyway, you can't go anywhere, any place where, because there's a hold on you and you got a high bond in the other case. So this matter is set for next Tuesday at 8:30 a.m. for a pre-exam conference.
Thank you, Your Honor.
And Mr. Gibson, thank you for being here on short notice. All right, Mr. Wooster, see you on Tuesday. Paul, I sent you those emails about Christopher Pontius. And he's kind of half in and half out. The notices the court sent were sent to the wrong address. They gave you the right address, but I don't know whether he got a notice. I listened to the video, or Laura did. We never actually excused you as counsel. One option, we'll have to reset it unless the prosecutor simply recharges it as civil infractions. If they are civil infractions, he wouldn't be entitled to court-appointed counsel or a jury trial. But we'll cross that bridge when we get to it. But have you had any success in getting in contact with him?
I'm pretty sure that I called and left a voicemail. I didn't, nobody picked up, but I was, from my memory, able to leave a voicemail. So hopefully he'll get notice that, he doesn't have to appear next week, I guess.
All right, well, we'll see how that plays out.
I don't know if I'll be here that day, but I guess.
Well, all right, you don't need to come all the way over here on the off chance that he'll show up because we won't be doing it. But Angelique, I talked to Jordan. She tells me that you two have been working on her case and you and Tim have been working on his case. So thank you very much.
You're welcome.
All right, Miss Wallers-Penner, would you come up, please? Good afternoon.
Good afternoon.
Are you Tracy Ellen Wallers-Penner?
I am.
Of course, I know you, but I have to identify you for the record. You're here with your lawyer, Jordan Harden. Also present is Angelique Camfield from the prosecuting attorney's office. This case alleges a domestic assault that allegedly occurred in October on the 18th involving your daughter. The matter is set for what's called a final pretrial here today. Ms. Camfield, what's the status here?
It's my understanding after speaking with Ms. Harden that the defendant's going to enter a plea of guilty as charged. There will be no deferral. If necessary, I'm willing to do a no contest.
Well, let me talk about this, Ms. Wallers. Domestic assault is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. If you plead no contest, You gotta take your gum out.
Oh, sorry.
There's a Kleenex
I
right
meant
there.
to before.
You don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. And I would get the factual basis from the police report or affidavit of probable cause or something else. Do you understand that?
I do.
And are you gonna plead no contest to this charge?
Your Honor, we had spoken in the hallway with what Ms. Campfield indicated to me she was planning to recommend to the court as far as a sanction. My client indicated she had no issue with the probation if ordered. I don't know if I guess I don't know where she got the understanding that she wouldn't have to enter any kind of plea today to get on probation. So the offer is you plead guilty or no contest to the domestic violence charge. The prosecutor has indicated to me they're going to make a recommendation for probation with some deferred jail time and some potential treatment for substance abuse, alcohol abuse of that nature. So that's the offer today. If you choose to accept it, we'd enter the plea today, come back at a later date for sentencing, make our argument, provide any evidence we wanted to the court to try to mitigate your sentence. If not, then we leave the matter on for jury trial.
Okay, so it doesn't make a difference if I say guilty or no contest?
No contest, correct, yeah, no contest if you don't have a clear memory of what happened.
I will enter that plea, no contest.
You will plead no contest?
Yes.
All right, let me ask you a couple things. Did anybody threaten you to get you to plead to this?
No.
Promise you anything?
Nope.
Do you understand that if you do plead to this charge, no contest, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that? There will be no trial if you plead no contest.
I understand what you're saying. I didn't know that that was the same as guilty.
Well, it results in a conviction and then a sentence where I could put you on probation. But I don't have authority to do anything to you unless there's a conviction, either by plea of guilty, conviction at trial, or a plea of no contest. So if you do plead no contest, there won't be a trial. Do you understand?
Yeah, okay.
Or if you had a trial, Ms. Harden would be there with you through every step of it. You'd also have a right to hire a lawyer of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not have a right to testify and did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless they were able to prove your guilt beyond a reasonable doubt. Understand?
Mm-hmm.
A man named Mr. Rhodes was here last month and then earlier this week, and he told me, you don't look people in the eye enough. He said, you're always looking at the damn screen. And I guess I'm guilty as charged. So I've been trying to, instead of looking at the screen over here, looking at the actual people. And so, Mr. Rhodes, I'm trying to do better, looking people in the eye. All right. There is an affidavit of probable cause in here, Ms. Wallers, and I saw it and my heart sank. Your daughter Brielle says that you had assaulted her. Her mother was very drunk and her mother came in and yelling at her, asking for smokes. And then there was an argument and you pulled her hair and then some other struggle and you fell on the couch and it was unpleasant all the way around. But that's a sufficient factual basis for me. Is that acceptable to you, Ms. Campfield?
Yes, Your Honor.
Jordan?
Yes, Your Honor.
That affidavit was prepared by Sergeant Jeremy Marsh of the Sturgis Police Department.
And Your Honor, I could just put, I believe the affidavit would reflect that this happened on October 18th, 2025 within the county of St. Joseph.
Yes, thank you.
Thank you. I would make it a little bit of an unusual request. Because the defendant is on bond and not supposed to be drinking or using any illicit drugs, she does have an extremely severe alcohol dependency. After this particular incident, when they located her, she was at a 0.32 blood alcohol level. And I've received information from the family that subsequent to that, she was also found unresponsive at home, and when taken to the hospital, had a blood alcohol of 0.57.
Oh my, 0.57?
So that most likely why she was unresponsive would have been most assuredly alcohol poisoning at that point.
That's the highest
I would
level
like
I've
her
ever seen.
tested today.
I don't have anybody to do it. She'll have to either go to Three Rivers. Autumn's not here today.
Darn.
She's at a training conference.
Okay.
And she's the only one certified to take a sample. Are you?
Just PBTs.
All right. Well, we could do a PBT.
That would be, if that's what we can do, that
Now,
will take.
I know Miss Waller, and I know that Penn Waller, she was in my sobriety court program. And I spent a lot of time with her. She's an intelligent woman. And that was a few years ago, maybe 8 or more.
It was like.
How long have it been since you relapsed?
Oh, it's just been within this last year.
So you've been sober for 6 years?
15. Was it 2015?
Well, I can look at-
2016, and so 6 years, something like that.
Let's get a PBT. Do you have one here? I think we do. Probation has one. If anybody knows where anything is after the flood. So I know that you can be sober, but this is like danger zone.
Your Honor, if I may request the court also, I think this is one of those occasions where we would need a PSI for a domestic violence charge of this nature.
All right, I'm not opposed to that. Who is Bill Hack to you?
My stepfather.
From the appliance store?
Mhm.
I've known him for years and years and years. Are you employed?
I was. I am not currently.
Where were you employed?
At Meyer.
As I said, when I knew you, you were a very intelligent, capable person when we got you sober. The law requires that I adjourn the matter at least 10 days to provide notice for the complaining witness to be here. The problem is if I do a pre-sentence investigation report, it's going to take longer than 10 days to do that. There's a no contact provision. Who's out of the house?
Riel.
So you're in your own house and she's staying somewhere else.
She's with her aunt, yes.
Who else is at your house?
Her father, Stephen Penner.
And she's your stepdaughter?
Biological.
Biological daughter, okay.
My understanding is the no contact is no assaultive.
Yeah.
Well, let's take a look.
That's what the bond conditions I have reflect.
All right, well, let's see. Struggles, no contact entered. As victim is 17, they lived in the same house since the incident, no problems.
Right, the
So-
pretrial release shows provision.
So there
R.
is not a no contact provision, and somebody went the extra mile to let me know why they called it that way. So the conditions you do have personally appear for every hearing, abide by any judgment, do not commit any crime while released, make reports as directed, do not use alcohol or controlled substances, do not purchase or possess a firearm, do not have any assaultive behavior against this person who is a minor. But there is not a no contact provision. But the fact that she's probably staying somewhere else. The problem is that when you have an addiction to this extent, when the judge says, don't drink anymore, you can't just turn it off like a switch. Your body's screaming for alcohol. And so you need to do something about it. Are you in any sort of treatment right now?
I am looking to start some counseling, but I've also had a huge medical mystery that we finally just got solved, and I started treatment for it 2 days ago.
Well, I'm considering medically assisted treatment for you. But do we have a PBT here?
We do not, but we could call Senator Constantine if you wanted us to do.
Would you please?
Yes.
Tab, do we know where probation's PBT is? We got flooded downstairs and probation is in the wind. One probation aide, they're working remotely till we get their new office space ready across the street. Well, let's pick a date for the sentence. I'm pleased we were able to resolve this. But at one time you were active in AA, you had a sponsor, you had individual treatment.
Kev says it's still downstairs, but it hasn't been calibrated in a long time.
And none of the three, nobody knows how to use it, so. All right, we'll get some assist here. That's our benchmark. Shana gets that.
Thank you.
Thank you. Tracy, I've heard stories of very high blood alcohol levels like that. They had something in Detroit they called the 700 Club. The people that had a BAC, but they were all deceased. That was in their autopsy. And that's generally where 5.7 is. It's in an autopsy report.
Well, and Your Honor, I would just state that's, hearsay that's been provided to the prosecutor. We don't
Yeah,
have any
it
kind of
isn't
verified
evidence in
proof.
this case, but it's frightening. Now, the prosecutors declined to do a deferral in this case. I don't know if you had a previous domestic violence, but I can only do the deferral if the prosecutor consents. All right. So today is February 26th. Jordan, are you available Monday, March 30th at 10:30?
Yes, I should be able to make that work.
Anyway, you know how to go to an AA meeting.
Oh, yeah.
When's the last time you went to one?
It's been a while, but I had gone 15 years straight. Unfortunately, my sponsor died. So
the common denominator in sobriety court, people that relapse is continuing to, or failing to stay in AA.
And part of it, Your Honor, was I was the lead in bakery and I could work from 6 a.m. till whatever, or noon to 8:30. And we weren't getting our schedule till a couple days before the new week. So even making a doctor's appointment was almost impossible.
All right.
It was
Well,
very difficult to have a
my
reliable
hope for
schedule.
you was that you would have been somebody else's sponsor. Did you sponsor others while you were in?
I helped others. I wouldn't say I officially sponsored them. I was dealing with, work and Brielle and
I believe your previous probation officer was Gina Wagner. She was excellent, but she's no longer with us.
Can I comment that the other charge that they say I have was from that 2015 DUI?
All right, let's take a look.
The basis for not offering the deferral was that OWI conviction had a tag along child abuse with it.
Well, that's in their discretion. I do remember that. Now, we've learned that if you do an OUIL and child endangerment alcohol charge, it prohibits you from getting an interlock device. We've got a guy in sobriety court right now who's doing absolutely great, and he can't get an interlock. So what they were doing back then was taking an OUIL and then a child abuse neglect charge, which wouldn't affect your driving privileges. So if you get the motor vehicle charge under 257 with a child in the car, they will not allow you to get a restricted driver's license with an interlock, even if you're in sobriety court. And we knew this a long time ago, and we've known it for a long time. So very often they will take that charge out of the motor vehicle code and put it under the penal code, a misdemeanor, child abuse attempt or something. So that doesn't affect your ability to get an interlock.
I've said we could get a road officer. to come over.
They've summoned one. So that allowed you back then to get your interlock. But so it does show as a child abuse, but it was Brielle the child that was in the car?
Mm-hmm.
Oh my. Set for sentence March 30th. Is the PBT going to show alcohol in your system? Could. Now, you're not to use any drugs or any alcohol. The drugs include marijuana, which is lawful for adults to use for recreational purposes. But while you're on bond and probation, we prohibit it. You can take any prescription medication that's prescribed, anxiety medication, pain medication, antibiotics, whatever, you can take that. But unless it's prescribed by a doctor. And I'm serious, it's very, very difficult to just stop. If it was that easy, you would have already stopped. Now you got me hanging jail over your head, which is an extra impetus to stop. But you need to do something. You need to get back into AA. You need to get plugged in with somebody at Pivotal or somewhere else. Perhaps get some medical assisted medication. But you aren't going to be able to hold your breath. Now, what I have envisioned here the prosecutor's looking for some substance abuse counseling. There's also the Women's Anger Management Program, which you're probably going to be put in. But you could get a head start on this by getting your counseling set up in advance between now and March 30th. We had some bumps in the road, I remember, but you did actually complete the program and graduate.
Yeah,
Yes.
it was, because my creatine was always low, so, which equals positive, and so I spent many a weekend at the country club.
Well,
and I found out that it is abnormal low all the time, has been for years. Still, I have a thing from every time I've been to Brunson Hospital, I had some surgeries, they've documented it, and it's always low. It's always diluted.
Well,
also from the type 2 diabetes.
And I don't know if we knew about type 2 diabetes back then.
No, at the time Sturgis Hospital said no, but I ended up going to Fort Wayne and.
Because we did look into it. You kept having diluted tests, and we've struggled for the entire tenure of sobriety court with dilutes.
Yeah.
And we discussed this 10 years ago. Many programs, a dilute was an automatic jail sentence. Swift and Sure, some of the other ones, a dilute was just assumed to be an attempt to mask the results. And so we do a few, we do some sanctions, then there'd be jail, and then you get out. And I remember we had one guy in particular who we finally did discern he had a serious kidney problem. And he started to get treated for it. He did graduate. All right, we're waiting for local law enforcement. I don't know, Centerville and Constantine share a jurisdiction, so sometimes the Centerville officer's in Constantine. All right. I'm going to ask you to step out with the officer, take the preliminary breath test, and then we'll send you out to the counter to get set up for your appointment for the pre-sentence investigation. I can remember things that happened 10 years ago. Just can't remember what happened yesterday. Very good.
Thank you.
Tracy, that's a good sign.
Your Honor, the drinking was more of like a binge thing. It was not a daily occurrence.
Well, you're binging to the point where you're almost killing yourself. So I don't want you to drink anything.
Okay. I just wanted to let you know that.
All right. But you have to develop a tolerance to be at the level 3s and certainly to be at the other level. So Jordan, I'll ask you if you take your client out to the counter, we'll get her set up for an appointment for pre-sentence interview. The sentence will be March 30th at 10:30. Any treatment stuff you get set up before that, bring it, share it with your lawyer because I want to know about it. All right, thank you.
Great.
All right, Ms. Canfield, thank you for your help. We have an important appointment. Yes, well, we'll put that in the file.
Had it signed, we went over it anyway.
At 3 o'clock for Deputy Metz's wedding.
Oh.
Frank asked me if I would marry him on 262626.
All right.
All right, we are on the record. We're going to do something we've never live streamed before. We're going to live stream a wedding ceremony. Most of you know the groom, Frank Metz, Deputy Metz, who spent a lot of time as a bailiff in this courtroom. And his bride, Patrizia Ferrantini. They've agreed to have this matter live streamed so their family remotely and at other places can watch this. Your friends in California are saying, congratulations, I'm leaving the live stream on. So, the live chat on. It's my privilege to be able to do this wedding ceremony. District judges in the state of Michigan are empowered to do weddings. And I've done, I don't know, more than 100. I haven't done any in a while. My nephews, my kids' friends, and others, but it's a special privilege to be able to do them. So I have before me Frank Klaus Metz and Patrizia Ferrantini. We got an international cast here. Frank was born in Germany and Patrizia has Italian roots. So thank you for allowing me to do this. And would you face each other and hold each other's hand? Frank and Patrizia, you come before me today to be joined together in marriage. Marriage should be entered into with much thought for what it means to each of you, to the people in your family and friends, and in the eyes of the law. No one has shown cause why you should not be so joined. So therefore I ask, Frank, wait till I finish. Do you, Frank, take Patrizia to be your wife? And do you promise before these witnesses to be your true and faithful husband, to love and care for her before all others, through good times and bad, in sickness as in health, and to be patient, kind, and forgiving with her from this day forward? If so, answer, I do.
I do.
Do you, Patrizia, take Frank to be your husband? And do you promise before these witnesses to be his true and faithful wife, to love and care for him before all others, through good times and bad, in sickness as in health, and to be patient, kind, and forgiving with him from this day forward? If so, answer, I do.
I do.
Do you have the rings? All right, I'd ask you to exchange the rings. Very nice. The parties have exchanged rings, and as each of you has promised to be faithful and true to one another before these witnesses, hundreds of them, and have sealed this promise by giving and receiving a ring. Now, therefore, by the authority vested in me by the state of Michigan, I pronounce you husband and wife. You may kiss your bride.
Thank you.
I present Frank Klaus Metz and Patrizia Ferrantini as husband and wife. We're now going to close out this very brief ceremony. This is how mostly court ceremonies go. And then we're going to execute the marriage license and you'll be husband and wife. Thank you for sharing this. The comments all are greatly sending you hearts and kisses and congratulations. And even a mazel tov. And so thank you. We're going to end the live stream and we're going to execute these marriage licenses. And we will close out the record. Thank you for sharing this with us.
Thank you.
And thank you for sharing these cases with me, ladies and gentlemen. No, not just court cases tonight, right? I mean, Not every day you get to see a nice, quaint little online wedding in one of your favorite venues. I thought that was awesome. Man, the first blocks, we could go over those things one by one, but how can you? It's not. If you're interested, the description says it all. A like and subscription is appreciated if you are so inclined. Just to remind you all, I'm your humble Lone Wolf Oosel, and I do present these little courtroom compilations every night around 8 p.m. Central Time, 9 p.m. Eastern Time. I do it every day, same wolf time, same wolf channel, with the slight exception of Saturdays when we go live at noon o'clock Eastern Time. That's 11 a.m. Central Time. Oh, Jude Curio is Thunder Snow. Thank you so very much for your kind generous donation. It is through the contributions of people such as yourself that this channel is able to do what it does. So thank you very much for your consideration, and thank you everybody for hanging out with me. And come on by tomorrow, keep an eye out. Putting out regular videos again. I put out like 3 today. I thought they were pretty dadgum. They were good. Some of them were kind of funny. But for now, I'm going to say it again. I'm your Lone Wolf Oosel. I'm your humble host. I am the guy behind the fur. And I am out. I feel like there's a lot more I really need to say. But I really don't know what it should be. Well, not 9 p.m. 9 p.m. Eastern Time. 9 p.m. Eastern Time, not Central Time. Yeah. Always. Friday night, Monday night, Tuesday night, every weeknight. Take Sundays off. Sunday's a good day to take off. You know what I'm saying? Love you guys. You're awesome. Integrationing. We're here for exactly 1 more minute. 1 more minute. Well, unless something special comes. If you know, you know. There once was a guy from Nantucket who put all his pennies in a bucket. I'm not gonna finish it. I don't know. I was trying to be funny. I'm not that funny. We're going to see Hutch. Sovereign Legal Encounters is up next. See you guys there. And I have a secret. Actually do have a secret. You're all awesome. Don't tell anybody. It's my secret.